Special United Nations Ambassador GERARD NSENGIYUMVA, and I'd like to share with you about human rights mechanisms. There are multiple human rights systems, international, national, and regional. International, regional, and national in that order. They are made of instruments, for example, treaties and mechanisms, for example, commissions or committees, courts, and they exist at various levels, universal or regional or national. Human rights can be legally binding, for instance, conventions and treaties, or non-binding the documents that are relevant to the protection of human rights in general, for example, declarations. So human rights mechanisms are entities established with the purpose of overseeing the implementation of specific human rights obligations. Human rights mechanisms can take a wide variety of structures and functions. They include, for example, committees or bodies of experts, which are usually standing, although the members may serve for a predetermined term. There are councils whose members are elected or serve for a predetermined term. Commissions or fact-finding missions usually tasked to investigate a specific situation. Special rapporteur or independent experts or working groups who are experts or groups of experts appointed to investigate and report on a specific thematic or geographically delimited human resource issues. Then the intergovernmental organizations or their subsidiary agencies or institutions aimed at assisting and or assessing states' implementation of their human rights obligations. National human rights institutions established by states by law or constitution that function independently, and they have a broad mandate to promote and protect human rights at national level. So those are institutions that we hereby refer to mechanisms. So universal and regional human rights mechanisms can be divided into charter-based and treaty-based bodies. Charter-based bodies derive their establishment in the charter that founds an organization. For example, the Human Rights Council was established by the resolution of the General Assembly, which as the principal organ of the UN derives its authority from the UN Charter. The Inter-American Commission on Human Rights is an example of a regional charter-based body, as it was established under the Charter of the Organization of American States. Treaty-based mechanisms are linked to specific human rights instruments and oversee the implementation and obligations contained in the specific instrument. Each state party to a human rights treaty has obligation to take steps to ensure that everyone under its jurisdiction can enjoy the rights set. But in the treaty, the treaty-based mechanisms help them to do that by monitoring implementation and recommendation, or recommending further action. So universal human rights mechanisms actually we can talk about also sources of UN human rights mechanisms. There are mechanisms established by UN human rights treaties. As we saw, the UN has played a propelling role in the elaboration of a number of instruments for the protection of human rights. They range from the UDHR, Universal Declarations of Human Rights, which is spelled out basic human rights and fundamental freedoms, to the 9 core human rights treaties which have since elaborated specific human rights in instruments which are binding on states that have ratified them. In order to assess the effectiveness and the impact of the protection afforded by the UN human rights instruments, each of the 9 core human rights instruments contain provisions that lead to the creation of a treaty body mechanism, and the UN treaty bodies are tasked with supervising and implementing their treaty obligations, as shown in previous lessons. There are currently exist 10 treaty bodies, one per treaty, plus the subcommittee on the prevention of torture and other cruel, inhuman, or degrading treatment of punishment established under the optional protocol to the Convention against Torture. Common features of UN treaty bodies. The structure and functions of each treaty body is prescribed by the treaty. It sets out to monitor that said the treaty bodies share some common features, which are their committees composed of independent experts who serve in their individual capacity and who do not report to the states they are nominated by. Members are nominated based on their high moral standing and their recognized competence in the field of the specific convention. The committee is to monitor. They do not receive a salary for their work, and the UN provides them with the secretarial support. The composition of the committee must respect criteria such as geographical, gender, and minority balance. They all have time-bound mandates, usually set at 4 years. All committees meet regularly, although the number of meetings depend on the previous provisions of the relevant treaty. The tools and measures committee may use to monitor state implementation typically include receiving and evaluating periodic reports by states and providing recommendations, receiving and dissenting on individual complaints and violations of their respective convention, elaborating general guidance in the form of general comments, general recommendations on how states can best implement the respective convention, sending individual communications or making statements on human rights issues within the scope of the respective convention, reporting obligations, the reporting cycle and opportunities for UNHCR and other human rights organizations. All 9 core UN human rights treaties impose the obligation of periodic reporting upon states parties. The reporting period varies depending on the treaty. The chart is a chart that shows those periods. The typical reporting cycle, which aims at assessing a state's compliance with this treaty obligations and through recommendations to improve its ability to effectively protect the human rights of the individuals on its territory. UNHCR, as well as other UN agencies, non-governmental organizations, national human rights institutions, and other organizations can play a very important role in the reporting cycle by supplying information in alternative reports or confidential reports. In the case um, of UN agencies, they provide the committees and experts with a broader um, picture on the human rights situation in a given country. This allows the treaty body to be better to better assess that state's report and to come up with issues and questions in um, in a way that this contribution increases the accountability of the state and the credibility of the reporting process. Actually, there are standard reporting procedure. There is also a follow-up procedure. In the concluding observations, the reporting state may be requested to report back to the committee within a specified period on measures taken to follow up on certain recommendations. This provides another opportunity for engagement by UN agencies and government organizations and other stakeholders as the follow-up reporter will use information from the state and from other sources to assess whether the issues identified have been addressed by the state party. Treaty body issues its concluding observations. The concluding observations of the treaty body are the outcome of the reporting process and contain an evaluation of compliance with the treaty obligations by the reporting state. They also contain recommendations on how the state may achieve better protection of the rights enshrined in the treaty. The concluding observations also highlight areas of concern that should be addressed in the next reporting cycle. At times, they may also request follow-up reports, typically due after 2 years on specifically high-rated issues, because the concluding observations reflect the treaty body's understanding and interpretation of the substantive rights contained in the treaty. They are important not only for the reporting state, but for all state parties and for all organizations promoting human rights. State party submits its report. In its report, the state party must show what it has done to implement the rights envisaged by the treaty, for example, through legislative initiatives, amendments to existing legislations, policies, campaigns, and so on. As the realization of rights may be progressive, the state's previous report serves as a benchmark for assessing what has been achieved since. Then, constructive dialogue between the state party and committee during session. Upon receipt of the state's response, the committee starts a constructive dialogue during which it examines the state's report and its answers during committee sessions. At times, the committee invites state representatives to appear before it and answers questions by experts. The treaty body presents the state party with a list of issues and questions. The committee presents the state party a series of issues and questions based on the report the state submitted, as well as alternative or shadow reports. These alternative reports can be submitted by UN agencies, international and local non-government organizations, national human rights institutions, and academic institutions, and allow the treaty body to gather a more balanced view of the real human rights situation in the specific country incorporate more pertinent and probing questions and recommendations for the third party. The state party may submit replies to the list of issues and questions. States can submit their replies to the committee questions in writing. Stakeholder briefings in advance of the state's review. During the relevant session of a committee and before a constructive dialogue is held with the state delegation, UN agencies including UNHCR, international and local non-government organizations and other stakeholders may also have the opportunity to brief the committee in person or via video conference regarding the human rights situation in the concerned state. UN agencies and national human rights institutions may brief the committee in closed meetings, while non-government organizations and other stakeholders typically brief the committee in public meetings. Simplified reporting procedure. Some treaty bodies have a simplified reporting procedure that the states may choose. Under this procedure, a list of issues prior to reporting, which is called an LOIPR. LOIPR, list of issues prior to reporting, is prepared for the state before a state report is received. The state report is then structured in the form of a reply to the list of issues prior to reporting. As with the list of issues procedure, UNHCR and other stakeholders may provide reports in advance of the committee preparation of a list of issues prior to reporting and or in advance of the constructive dialogue session. Step 1. The committee sends a list of issues prior to reporting, which is called LOIPR, to state party. Step 2. Replies to the LOIPR constitute the state party report. Step 3. Constructive dialogue between the committee and the state party delegation. Step 4. The committee issues its findings and recommendations, concluding observations. Then step 5. Follow-up and implementation of the committee committee's recommendations. Then here comes the reporting frequency. State reports are submitted the following specific guidelines set out by each committee for periodicity of reporting for each committee varies based on terms of the relevant treaty and on the practices and the procedures established by each committee. For instance, ICERD treaty, initial reports within 1 year, periodicity of reports 2 years, but de facto 4 years. De facto periodicity since 1988. CERD allows merging 2 reports into 1. Then there is ICESCR. The initial reports is within 2 years, and the periodicity of reports is 5 years. Article 17 of the ICESCR states that ECOSOC shall establish the reporting periodically under the covenant and so it did in its resolution 1988 slash 4 C Rule 58 of CESCR's Rules of Procedure. ICCPR 1 year is the initial reports within, and 3 to 6 years periodicity of reports. The average periodicity is 4 years. However, in line with the Article 40 of ICCPR, the Human Rights Committee exercises its discretion to decide when periodic reports should be submitted, and it does so depending on a state party's level of compliance with the provision of the Covenant. See Rules 66 and 71, 70 in brackets 1 of the Human Rights Committee Rules of Procedure. The number of years chosen by the committee for the periodic report is decided by the committee on the adoption of concluding observations and of each state, and is based on the committee's view. It's based on the committee's view of the human rights situation in the state party conceived. Then there is CEDAW. The initial reports is within 1 year. The periodicity of reports is 4 years. Then the CAT, the initial reports is within 1 year, while the periodicity of reports is within 4 years. Then the Treaty of CRC, Convention on the Rights of Child, initial reports is within 2 years, while the periodicity of reports is 5 years. About CRC-OPAC, initial reports is within 1 year, and it's integrated into next CRC report. For a period of CRC report over for a period of 5 years for states not party to CRC. Into next CRC report over 4 to 5 years for states not party to CRC. Then there is CRC and OPSC. Initial reports is within 2 years, and the periodicity of reports integrated into next CRC report every 5 years for states not party to CRC. ICRMW, initial reports is within 1 year, while the periodicity of reports is 5 years. CRPD, initial reports is within 2 years, while the periodicity of reports is 4 years. ICPPED, initial reports is within 2 years. CED does not refer to initial and periodic reports. So that is briefly what we need to know at this moment, and I thank you very much for watching.